everyone, and welcome to the next video in our Emerging Markets series. My name is Phillippa Hook. I'm a Senior Associate in our London Disputes Resolution team with a focus on energy, oil and gas, and construction. I'm joined by Paul Stothard, a partner in our Dubai office. He's also a dispute resolution lawyer with particular experience of international arbitration and commercial and investment disputes. So, Paul, tell us why our clients should be thinking about parent company liability.
Thank you, Pippa. There's a trend in recent years of claimants attempting to hold UK parent companies liable in the English courts for the acts of their subsidiaries or third parties in relation to harms suffered by claimants located overseas. As you may know, some of these are high-profile proceedings which have involved, for instance, claims in relation to environmental damage allegedly caused in the energy and mining sectors. These cases are all very recent, and while some key themes have emerged as to how the courts may respond, at this point, the judgments concern jurisdictional challenges and challenges as to whether an arguable case exists under English law as to parent company liability for the actions of a subsidiary. It remains to be seen whether these cases will proceed to trial on the merits, and if so, what outcomes will follow. Nevertheless, the trend of claiming against the parent company is likely to continue. So it's important to understand the factors which contribute to the risks of such liability and the threats and opportunities they present to your business. While these developments are relevant to almost all of our clients, those with operations in emerging markets are perhaps the most exposed to potential liability for the acts of subsidiaries, contractors, or supply chain participants. And this is because subsidiaries in emerging markets may be more exposed to environmental, social, or health and safety risks, and also because the parent companies are likely to be identified as having the deeper pockets and therefore be the more attractive target in any given litigation.
There are a number of factors which may contribute to a finding that a duty of care exists between a company and its subsidiaries. Here are some examples. The parent company manages or jointly manages the relevant activity. The parent company gives defective advice to the subsidiary or promulgates defective group-wide policies which are implemented by the subsidiary. The parent company issues group-wide compliance policies. The parent company is involved in the implementation of group-wide policies, such as for training, supervision, and enforcement. The parent company holds itself out as supervising or controlling a subsidiary, even if it does not in fact do so. The company operates under a vertical corporate structure where all local level decisions must be first approved by the parent. There are services agreements between parent and subsidiary, although this may be less persuasive. Or there are contractual undertakings relevant to the alleged duty of care, for example, safe vessel demolition or ESG undertakings.
There are four ways in which we believe that these recent changes may affect your business. First, potential extended liability. Since any extensions to the existing parent company liability mean that the parent company may be found liable for the act of its subsidiaries, contractors, or supply chain participants, the way in which a parent company has calculated or provisioned for litigation risk in the relevant insurance coverage, business risk strategy, exposure limits that your business is prepared to accept, and so forth, may no longer be adequate. Clearly, if the liability is to extend to the parent company in any particular case, risk mitigation strategies and related insurance and reporting structures may need to be revisited.
Second, compliance and audit costs. As the parent company's litigation risk increases, so do compliance and audit costs. Many companies choose to investigate the state of affairs at the local subsidiary level or in their supply chains in order to understand whether and what action to take to respond to these recent developments in case law. It is key to keep in mind there is no right or wrong answer as to whether parent companies ought to seek to remove themselves from or to take more control over their local subsidiaries. Whichever strategy your business decides to adopt, it should be a well-informed one. We would recommend that it is developed in collaboration between individuals from across the business who understand the entire spectrum of risks and the opportunities linked to either approach. We would, of course, be delighted to assist you in any such projects.
Third, operational strategy. As to the risk associated with operating in certain parts of the world, as these risks increase and may now be extended to the parent company directly, it may no longer be profitable to continue running such operations. This may open the door for restructuring projects. In a way, in the aftermath of the pandemic and in a rather turbulent year for the markets, now may be as good a time as any to consider whether restructuring could offer cost and operational efficiencies. Many of the corporate structures of our clients have been designed in a very different regulatory and business landscape and may not account for parent company liability risk, pressures linked to energy transition, or the new challenges posed by the post-pandemic reality.
And finally, very briefly, reputational risk. Even if the claim against the parent does not succeed on its merits, being accused, rightly or wrongly, of falling short of ESG targets, or even worse, of actively contributing to environmental harm or violation of human rights, may make it more difficult for such companies to access funding at the best possible terms, enter into joint ventures with ESG conscious counterparties, or result in internal pressures from the shareholders.
So, the developments in parent company liability are likely to be relevant to your business as they pose threats and opportunities that fall roughly in these categories. These common law developments are happening in the broader context of a global shift in how companies conduct business and to what extent they link their business KPIs to the protection of the environment, human rights, and meeting climate changes. We'll be keeping a close eye on these developments and be reporting back to you as the picture remains clearer. But for now, Pippa, that's all.
Thanks for joining us today, and we hope you found this insightful. If you'd like to know more about parent company liability, please feel free to get in touch with Paul or me.